My lord, I beg to make a mention of item 9 of the hearing list, my lord. But this week, next week, I have some personal difficulties, my lord. This matter is kindly listed after 2 weeks. My lord.
You are for petitioner?
Yes, my lord. I am for the petitioner.
On pre-made by the petitioner. This is not after 2 weeks.
Oblige.
Your Lordship, can I, item number 12 and 13? Can this matter come up after 3 weeks, Your Lordship?
I'm appearing on behalf of the petitioner, my lord.
Chosen 13.
12 and 13.
You are for? Your petitioner. Any objection?
No.
On pre-made by the respondent. Your respondent?
Respondent number 1 and 4 for item number 12, and item number 13 is 1 and 2.
Who are you?
It's Shillong Contentment.
On pre-made by the respondent, contentment, Shillong Contentment Board. Matter is adjourned. And not objected to by petitioner. Matter is adjourned. This is after 2 weeks. 3 weeks. 3 weeks.
Much.
May I please, your lordship, I beg to mention item number 8. You are for the petitioner. And I'm appealing for the respondent, my lord.
On pre-made by the petitioner. This is matter after 2 weeks.
Much more.
Your Lordship, I beg to mention item number 17, Your Lordship. If this matter can be taken up after 3 weeks, Your Lordship.
17.
Yes, Your Lordship.
You are the?
Respondent, Your Lordship.
I am for the petitioner.
What's this case about?
This is a proceeding under 145, Your Lordship.
145?
Yes.
Oh, okay. That is it a school building or madrasa?
Pardon, Your Lordship?
What is the facts of the case?
Your Lordship, there is, after document was produced, Your Lordship, then the magistrate was passed on attaching the land of the petitioner as well as the respondent, Your Lordship. Restraining of both of us, Your Lordship, to enter the property, Your Lordship. That's the case, Your Lordship.
How long?
3 weeks, Your Lordship.
3 weeks. And pre-made by the respondent. This is matter after 3 weeks. Not objected to by petitioner. This is a matter after 3 weeks.
Legal right.
All right.
Supplementary cause list, item number 1.
My lord, I had come earlier with a petition under 482. Now I have, after withdrawing that petition, I have come with a revision under section 397, my lord.
Yes, Mr. Bora, what is the matter about?
Yes, my lord. My case is that I had let out my tanker, one of my tankers, to one Kamal Chaudhary for monthly rental of 10,000. That was in 1st April 2004, I think. Then later, Kamal Chaudhary, this tanker was seized by police in connection with the NDPS case, where the tanker was found to be carrying contraband ganja. And that happened on 27th December 2005. And Kamal Chaudhary was arrested on the spot, nearby the spot, when he was trying to run away through Silchar by taking lift from any vehicle. So thereafter, Kamal Chaudhary gave a statement on 13th January 2006. That statement is Annexure 3. It's on page 18. He stated deposition. This is stated in a form for recording deposition, not under 164 also. He stated that my name is Shri Kamal Chaudhary, my father's name is Shri Karim Chaudhary, I am by caste Muslim, Bengali, my home is at Mauza, so-and-so, police station, so-and-so. I reside at present Mauza, etc., etc. On oath, on 27 December 2005 at 6:30 am from Guwahati, I came with Shri Haidar Ali, son of Manna Mia, hailing from Bataguli, opposite Guwahati Public School, Panjabari, etc. Started early and arrived at 12:30 noon at Thangskai Depot, Meghalaya, which belongs to Shri Haidar Ali, of which the land for using as depot was taken from rent from one Kachari. I have been quite a number of times and met the Kachari fellow who bought and procured coal for us from local dealers and stocked the coal there at the Thangskai Depot. We started on 6 December 2005 only for stocking the coal and making a makeshift shack over there to store and doing coal business purpose. On 27 December 26, when I was dropped at the spot by the owner Shri Haidar Ali for starting coal business here, he went straight to Silchar. He returned back from Silchar at about 6:30 evening in a sumo and brought 2 LP trucks inside the depot. On top of the trucks, I saw some scrap materials consisting of old tins, etc., and later some packets were unloaded from underneath the trucks. I then started asking what these packets of which the owner Haidar Ali told me they are materials for Ayurvedic medicine. Later, I came to know from one of the drivers of the LP trucks that it was cannabis ganja. Then I got angry with the owner and follower of Haidar Ali, Babu, and told him that for that night only, the rest we will be doing coal business only as promised. Then while arguing, he pacified us by saying that it's for that one day only. Then later at 8:30 p.m., the tanker from inside by NL02D6412 registration number original belonging to Sri Haidar Ali came, which was later changed to AS013977 on depot, and loaded the packets in the tanker from the LP trucks there. Then about 8:30 p.m. another 2 tankers came from Guwahati side and entered the depot. After some time the police came, and on knowing that we fled, the Kachari fellow, Haidar Ali, the owner, with other 3 drivers of the trucks to the jungle side, and later we went separate ways to travel to Silchar in the next morning, being in the jungle whole night, not knowing the way. Later I do not know about others. This is his statement. Only through this statement he has made me the culprit in the case. Now, he had given the original papers to the police, and the lease agreement by which he had taken the tanker on loan was suppressed by him. That is Annex 1 here. Now, with this, apart from this statement, the entire case record, there is no evidence against me, nothing against me, except this statement. After getting this statement on 13th January 2006, in September same year, charge sheet was filed and I was shown as absconder. So when I got the notice from the court, I appeared in the court, obtained bail, and I have been appearing there regularly. But the court proceedings were very slow because all the accused were not found together on the same date. So the court could not proceed further, always asking for the appearance of the accused. Then meanwhile, Kamal Chaudhary died. That also took a lot of time till his death certificate was finally deposited in the court. Thereafter, the judiciary separated in 2013. So from July, this case was transferred to Cleariat, but the court did not start. 2019, the court started, judiciary started in Cleariat. Then this case was re-registered as NDPS case 15 of 2019. And thereafter, the COVID lockdown came. So the court did not have any opportunity of hearing under 227. So it came only during last December. So at that time, I filed one application for discharge under 227. There I had pleaded that as per the one judgment I had given of the Supreme Court, which said that statement of a co-accused cannot be used as substantive evidence.
No, was the argument before consideration of charge heard?
No, not yet heard. I filed one application for
You should
discharge
have-
before
you
that.
should have-
Not yet heard.
You should have completed that. See that part. Appear before the trial court, make your submission or argument, and the court will decide whether charges are to be framed against you or not. In all probability, it may not.
Only
But
my
then why have
part
you-
already court has finished, because as other 2 to 7 I had gone.
What is the
What I had argued in the court that
what
had
is
gone
the
by the impugned order.
what is oh okay? Impure order says that charges are to be framed against you.
Yeah, for me there will be no more chance. Other 2 will have the chance. That means
Where is the
out of the 3,
Where's
those 2 were absent.
impure order?
It is order is against me only.
Page 26 is the relevant portion.
Page relevant portion is 26. Yes. Upon last paragraph, upon perusal of the materials on record and in the facts of this case, this court is of the view that since the lease agreement enclosed to the application is not a registered deed, and on the facts that the seizure was made from the tanker at the depot rented by accused Hyder Ali, which facts requires the test of trial, and this court, without being judgmental but for consideration of the application under 227 CRPC, is of the view that the lease agreement material is not convincing for consideration at this stage. This court will not go into the depth of to sift evidence out of the disputed statements of the accused Kamal Chaudhary, as that is for the stage of trial. The relied judgment not to be based on confession of co-accused is agreed by this court, but for its application to the accused herein will be after the evidence is recorded. The application for discharge of accused Hyder Ali is rejected and disposed of. So for my case, it is disposed of.
Yes.
Now my point here is that these grounds
Yes.
which
I've heard. We are not. See,
court below had.
we are not in the final stage of hearing.
Okay, my lord.
First notice has to be issued.
Yes, my lord. Records may be called for, my lord.
Yes, you are appearing for respondent.
On behalf of the respondent states,
So what is your submission?
my lord, the stand taken by the court, by the honorable court, my lord, this is very correct, my lord.
I'm
My
disputing
lord,
that.
unless evidences are gone into my lord, how can the conclusion be reached? It's a simple fact, my lord. And this is a case of NDPS, my lord. And it is not one. It's
Now,
a
my lord,
whole
the
tanker. my lord.
evidence of this witness cannot be taken because he is dead.
That is true. That is true.
And this is not even a dying declaration.
But as far as framing of charge is concerned, that would be the prerogative of the court
My
concerned.
lord.
Only this statement, nothing else is there. Now, this statement, the
As
person
court-
who gave this
the court
statement
has
is no
right-
more.
The court has rightly observed that for you to be able to justify your stand,
My lord.
evidence has to be
The
evidence has
grounds
to be
taken by
recorded.
the court, I refute. Because,
My lord, there
for
are
example,
other
firstly,
co-accused.
registration.
There are certain co-accused.
Registration of the deed.
Yeah, that is true. That is true. You are going to the facts.
Yes.
My lord, there are other co-accused, my lord, who are absconded.
Those co-accused are also giving the same version.
That, you see,
They are not absconding.
the
They are
court-
presenting
even
presenting
whatever the
in
case
court
may
every
be,
day.
whatever the case may be, the court will deal with that.
My lord.
There are provision in the CRPC for bifurcating the trial, so on and so forth. So that will go.
That is the point I am refuting in this petition, my lord. That
This very
there is
facts,
no ground to proceed against me in the trial.
my lord, this very
As
facts.
given by in several cases by the Supreme Court, that when there is no ground to proceed against
So we'll hear the matter
discharge is
when.
My lord, next week I have some difficulty. Thereafter, any date, my lord.
2 weeks. Heard Mr. Kibora and counsel for the petitioner. The state respondent is represented by Mr. K.P. Bhattacharjee, LRGA. As such, no formal notice is required to be issued as paid for by the parties. Are records necessary? Not, I don't think. The impugn order will speak for itself. The impugn order will speak for itself. I don't think records are necessary.
Case records.
Otherwise, records may be called. I have
Not necessary. The court will not have to go into statement
Yes,
under
only the impugn
161.
order only. Regarding the impugn order only.
if there are any
You have
other.
you have come by way of revision, so it only the test of jurisdiction will be looked into.
Only if, my lord, if there is
Case
any
record
other,
will have only the proof of the death of Kamal
only
Chaudhary.
other material on record if it is there.
That case record may
That
record.
I think that stage is also, you see, gone into by the trial court.
My lord.
So it is not for this court to again go and see whether
And it will not
there
be
are
wise to call
materials,
it now because,
whether they have been considered. That would be, for the appellate court to do it.
Yes, ma'am.
This is matter of the 2 weeks. This is matter for hearing.
Item number 2.
Please, Lordship. On the last occasion, I take time just to get the instruction from the concerned prisoner that this case has been succeeded. What happened in this case? Actually, there is an allegation against the petitioner by the private respondent that petitioners have kidnapped the private respondent. However, now the case has been succeeded, and then during the case is pending. During that course of when the case is pending, the respondent himself want to compromise the case that he has actually executed deed of the compromise, also saying that he don't want to pursue the case, and he has filed those FIR by mistakenly. So I pray that maybe notice may be issued to the private respondent. Let he come and make a statement before his court. I have enclosed even their deed of compromise, also the FIR, Lordship.
There are 3 petitioners.
Yes, there are 3 petitioners. Private respondent is the person who filed the FIR.
Was allegedly kidnapped.
Yes, Lordship.
So, Mr. Sati,
Let notice be issued, madam. In the meantime,
you are accepting notice on behalf of?
we are only on behalf of the state, madam. That is respondent number, my lord,
1, 2, and 3.
my lord, Yes, the numbering, some problem with the numbering. Yes, madam. 1, 2, 3.
What Mr. P.D. Samal, letter counsel for the petitioner. Mr. K.P. Bhattacharjee, letter J, has accepted notice on behalf of the respondents 1, 2, and 3. As far as respondent 4 is concerned, the petitioner has submitted that he may be allowed to take steps for issue of notice. The notice be issued accordingly, the same returnable within 2 weeks.
Lordship, I also
Yes,
pray for staying of the proceeding.
Let notice first.
Lordship.
Let,
Much blessed, Lordship.
Item number 2.
My lord, we have received the affidavit counter from my friend and the respondent.
Lordship, we filed.
Lord, yes. Lordship, give me 10 days. We'll file a short rejoinder.
Lordship, I have some submission. Lordship, we have also filed an affidavit quite some time back. We want to file an additional affidavit going on something or proper adjudication of the matter. Just a short additional affidavit before the hearing commences.
what is the requirement for filing a
Yes, they have filed in detail.
There's some documents that we want to.
Who are you?
Some grounds we want to.
Who are you?
I'm the private respondent.
Who is the private respondent?
I'm the chief.
He's the chief of the Langren Sameship. Okay. We challenge his appointment.
Heard Mr. H.L. Sangresu, letter senior counsel appearing for the petitioner, who has submitted that the affidavit in opposition filed by the respondent KCDC has been received, and to which the rejoinder affidavit is desired to be filed, but for which some time is prayed for in this regard. Pray aloud. Mr. M.L. Nupure, letter counsel for the respondent number 4, has also submitted that the counter affidavit on behalf of the respondent number 4 has been filed. However, through inadvertence, certain documents relevant to the issue connected with this case could not be filed at the relevant point of time. It is prayed that an additional affidavit may be allowed to be filed, bringing such documents on record.
Lordship, I will not exactly say documents, but I want to file my additional affidavit. Not exactly say documents.
Okay, so what exactly do you want? Some information?
Some information.
Atau kita mga document form na ito. Pray aloud. The said additional affidavit may be filed within the next date fixed, with advance copy to the petitioner to allow him to file a rejoinder to the same if so advised.
Yes. Our only concern is no further adjournment from their side.
Let us
Yes.
on prayer made, list this matter after 3 weeks. That'll give you enough time.
Hopefully they will not come for adjournment. But they have filed the detailed affidavit earlier.
Now they have shown their intent, so we'll
Let
see.
us hope within 3 weeks they file.
Item number 3.
Wait, please, Your Lordship. Your Lordship, I pray this matter may be taken up on Monday due to some personal difficulty on behalf of the conducting counsel.
On prayer made by the petitioner, list this matter.
Your Lordship, in the meantime, we may be allowed to get a copy of the charge sheet, Your Lordship, xerox it.
It has charge sheet has been filed.
File.
It is already shut-sheeted, Your Lordship. I think
You should have,
for that they'll have to get it from
In the
the.
meantime, Your Lordship, we'll just take a copy from you, sir, and then xerox
That
it.
you can do it.
You are not privy to the case diary, Your Lordship.
Not a case diary. Since charge sheet has been filed,
Your Lordship.
so whatever they are required, entitled to, that will be given to them. Of course, you see, it is the IO
It
who
is
should
from
have
the
it.
trial court, Your Lordship.
it's incumbent upon you to get it from the trial court.
Yes, Your Lordship, what happened is that on the 8th, when the matter was fixed, Your Lordship, the applicant here could not engage a local counsel there. That's why, Your Lordship.
But it should be in the court.
Okay, Your Lordship, we'll see to it.
What we can do is, okay, we'll fix this matter after 1 week.
Okay, Your Lordship.
In the meantime, you try to
Yes, Your Lordship.
get it through your colleague or whatever.
Okay.
Because you're entitled. If at all, suppose if you can't get it, then Mr. Shura will give you a copy.
Yes, Your Lordship.
Only of those costs.
Copy of the charge sheet.
Charge sheet.
Not necessary to specify what is required. You will get it. On premier by the petitioner, this is matter of 2 weeks or 1 week.
Let it be 2 weeks, Your Lordship. Let it be 2 weeks so that
Bail matter. This is matter of 10 days.
10 days. Okay.
Obliged.
Item number 4.
Therefore, the state. Please, Your Lordships. This matter has been heard by Your Lordships on repeated occasions. Well, it's, to cut the controversy short, there are basically three prayers made by us before Your Lordships in this writ petition. But I'll take Your Lordship straight to the prayers. Page 17, if Your Lordships kindly have it.
Yes, sir.
Your Lordships have it.
Yes.
Let's down below, if Your Lordship see, I'll just read the entire prayer. Under the above facts and circumstances, therefore pray that Your Lordships may be graciously pleased to admit this petition. Call for the records, issue rule calling upon the respondent, show cause as to why a writ of mandamus, certiorari, and other writ order direction should not be issued, directing the respondent authorities to. Let's hear. First is recover the salaries of the teaching and non-teaching staff of the petitioner's school for the period March 2002 to February 2003. So that is my first prayer, Millets. Then, Millets, the second prayer is from the managing committee of the said school, and further directing the respondent authorities to release the current salaries, area salaries, and other government benefits in favor of the petitioner's school, namely Rajpur Girls Upper Primary School, and to stop the benefits being given to the false school in the same name. So essentially, Millets, there are three parts to the prayer. First, Millets, the recovery of area salary for the period 2002-2003, Millets. That is the first one. Number two, Millets, for current salary in respect of my school, Millets, that is the second prayer. And the third prayer is that there is another school running by the same name. So we say that that portion of that, the salary which is being released to the other school, Millets, should be stopped. Now, at this stage, Millets, I would first deal with the first prayer before Your Lordships, and I'll take Your Lordships to the judgment and order delivered by this court. And Your Lordships would find it at page.
Mr. Paul,
Millets.
can you please go back to the
Facts of the matter,
facts of the
Millets. Which is why I'm taking Your Lordship straight to the judgment of this Honorable Court, Millets. That would clarify the entire aspect of the matter.
That is that page?
I'll just take Your Lordship first. This one? This one. If Your Lordships kindly have it, Millets, the typed copy is available from page 43 onwards. Your Lordships have it.
Yes.
If Your Lordship kindly turn to page 45, well, it's paragraph 2 onwards.
Yes.
It appears from record that this writ petition is filed for the third time by the petitioners for the same relief. The petitioners are the founder teachers of the school called Rajpur Girls Upper Primary School, Dadangiri, West Garo Hills, established in the month of January 1999. It is also the admitted case of the parties that the school, that is Rajpur Girls Upper Primary School, Dadangiri, West Garo Hills, is under the SSA scheme. The teachers of the school, that is Rajpur Girls Upper Primary School, Dadangiri, West Garo Hills District, are getting their salaries under the said scheme, that is the SSA scheme. The respondent number 4 is Deputy Commissioner cum Chairman of SSA scheme, West Garo Hills, Tura, where the said school is located. The Deputy Inspector of Schools, Dadangiri, West Garo Hills, by his letter number so-and-so dated 14th April 2004, directed the Secretary of the present school, that is Rajpur Girls Primary School, Dadangiri, West Garo Hills District, to make necessary payment of the salaries of the teachers working in the said school, which admittedly was under the SSA scheme. It is the case of the petitioner that in spite of releasing the fund under the SSA scheme for the payment of salary of the petitioner, the managing committee of the school, that is Rajpur Girls Upper Primary School, Dadangiri, West Garos, Tura, are not paying the salary to the petitioners. The petitioners had filed a joint writ petition in WPC number so-and-so in the erstwhile Guwahati High Court against the present respondents. The Guwahati High Court, by the order dated 18/3/2005 in WPC number so-and-so, had directed the respondent number 6, that is the District Mission Coordinator Sarva Siksha Abhiyan, West Garo Hills, to make an inquiry as regards to the allegation made in the writ petition that in spite of releasing the money of Rs 78,000 for payment of salary to the petitioners for the period from February 2002 to February 2003, the respondent number 8, that is the Secretary of the Managing Committee of the school, did not pay the salary to the petitioners and did not take necessary steps to remedy the grievance. It is alleged that the said school managing committee, did not even accept the copy of the order of the High Court dated 18/3/2005 submitted by the petitioners. The petitioners sent the copy of the judgment and order of the Guwahati High Court dated 18/3/2005 to the school managing committee. It is an admitted fact that the school managing committee had received the said order of the court dated 18/3/2005. Even the High Court passed the said order dated 18/3/2005 passed in WPC number so-and-so. The school managing committee did not pay the salary to the petitioners. Accordingly, again, it should be Melods, the petitioner approached the Guwahati High Court Shillong bench by filing miss case number so-and-so in WPC 99 of 2004. And the erstwhile Guwahati High Court Shillong bench passed the judgment and order dated 18/3/2005, which reads as follows. Her learned counsel appearing for the applicant as well as the learned counsel for the state respondents, the miss case has been filed for direction to the respondents, particularly respondent number 4, 5 and 7, to release the area salary of the teachers immediately. The learned counsel for the applicant submits that by letter dated 14/4/2004, the respondent number 4 has written to the Secretary President Rajpur Girls Upper Primary School, West Garo Hills, to make necessary payment of salary to the teachers. The said letter is annexed at Annexure 7 to the miss case. The letter reads as follows. The letter is reproduced. I'll just take your lordships quickly to the substance of the letter. It has come to the notice of the undersigned that you have not paid the salary under SSA to the teachers of your school. You are therefore directed to make necessary payment of the same completely within 1 week, failing which the undersigned will take necessary action, which may please be noted. It is indeed shocking that a superior officer's specific direction has not been complied with by the secretary of the school, and more than 11 months have elapsed from the passing of the letter dated 14/4/2004. Relying upon the said letter dated 14/4/2004, this court therefore directed the respondent numbers 2, 3 and 5 and 1 to look into the matter seriously and take necessary steps for payment of salary to the teachers within a period of 2 weeks from today, if necessary by making an inquiry as to the entitlement of salary of the teachers and by ascertaining the actual teachers serving in the school. Any order passed today in this regard and also payment of salary to the teachers shall be communicated forthwith to the learned government advocate appearing in the case to enable him to appraise this court regarding the steps taken by the respondents. With the above direction, Miss Case is disposed of. It is unfortunate that despite of the repeated directions of this court to the managing committee to pay the salary to the petitioner, the managing committee, for reasons best known to them, are not releasing the salary to the petitioners. In the present writ petition, the respondent numbers 1 and 2 had filed affidavit in opposition where they stated that the inquiry was conducted by one Shri S.R. Marak, Joint District Mission Coordinator, West Garo Hills, Dadangiri, and submitted his report that there are 2 schools in the same name, that is Rajpur Girls Upper Primary School, West Garo Hills. The fact remains that in spite of releasing the said amount of Rs 78,000 mentioned in the said letter, the Deputy Inspector of Schools, Dadangiri, for payment of salary to the petitioners of the said school under the SSA scheme, the petitioners are not getting the salaries. In the course of the hearing, writ petition Mr. So-and-so, learned counsel appearing for the petitioner, submitted that the said amount released by the government under the SSA scheme for payment of salary to the petitioners has been misappropriated by the school committee. To this fact, Mr. So-and-so, learned GA, appearing for the respondent number 1, 2 and 3, fairly submits that without any inquiry, the respondents 1, 2 and 3 could not admit that the said submission made by Mr. So-and-so, learned counsel for the petitioners. It appears from record that there is no healthy atmosphere so far as the school, Rajpur Girls Upper Primary School, West Garo Hills, SSA. Article 23 of the Constitution prohibits the forced labor. Utilizing the services of the petitioners without salary is nothing but forced labor, which is forbidden by Article 23. In this circumstance, this court has no alternative except to direct the respondent number 4, that is the Deputy Commissioner cum Chairman of the scheme for the Garo Hills Tura, to conduct an inquiry to find out who has misappropriated the said amount of Rs 78,000 mentioned in the said letter of the Deputy Inspector of Schools, Dadangiri, West Garo Hills, dated 14/4/2004, and the respondent number 4, that is Deputy Commissioner cum Chairman of SSA scheme for the Garo Hills District Tura, shall file the complaint criminal case against the culprits with the OC West Garo Hills within a period of 3 months from the date of receipt of a certified copy of a judgment of this order. The OC concerned is further directed to register an FIR on the receipt of the complaint from the Deputy Commissioner cum Chairman of West Garo Hills District Tura and arrest the culprit without delay. The compliance report should be submitted by the respondent number 4 Deputy Commissioner cum Chairman SSA West Garo Hills District Tura to the registry of this court. With the above observation and direction, this writ petition is disposed of. So your lordships have a brief backdrop as what has led to this litigation before your lordships. Thereafter, my lords, what had happened is that inquiry by the Deputy Commissioner was done, and your lordships would find it at page 57.
Yes.
In pursuance of the High Court order dated 24/9/2013 in the case of Faluda Biswas and others, your lordships have it, my lords, Annexure 8, page 57. While going into the intricacies of the case, directed to respondent number 4, that is Deputy Commissioner West Garo Hills cum Chairman SSA Garo Hills Unit to conduct an inquiry and ascertain the case and issue a misappropriation of rupees 78,000, which is the allegation made by the petitioners whose names are here under, my lords. The names are here. The respondents in the case are following, my lords. I jump. As per instruction of the Honorable High Court, the inquiry to examine the misappropriation of rupees 78,000 and filing of complaints criminal cases against the culprit was to be done within a period of 3 months from date of receipt of certified copy of the judgment and order. It was further ordered by the High Court that the officer in charge of the police station concerned shall register the FIR on receipt of the complaint by the Deputy Commissioner cum Chairman SSA West Garo Hills District. In urgent and total compliance of the orders of the Honorable High Court in the aforementioned case, the undersigned directed all the 4 petitioners, namely Faluda Biswas, Hamida Khatun, Mafidur Rahman and Muhammad Al-Farouk Hussain, and all the respondents, namely Deputy Inspector of Schools, President Managing Committee, Secretary Managing Committee, SD Sangma, who's the DSCO, C. Sengra R. Barak, the then Deputy Inspector of Schools, Guira B. Marak, SEO, Salsala Block Circle, Manoj Kumar Datta, SIC and MBC Salsala Block, and Shri Salman Haq, ex-president, Rajpur Girls School, in the case to come to my office chamber with all relevant material to be placed on record of inquiry by WT message number so-and-so dated 24/10/2013. All the concerned parties were asked to appear before the Deputy Commissioner of West Garo Hills SASA on 29/10/2013 at 11 a.m. The petitioners and the respondents in the case duly turned up and submitted relevant documents as well as depositions from the petitioner on the status of the case. Copies of the depositions made by the petitioner can be seen at Annexure 2 to Annexure 5, and the depositions made by the respondents may be seen as Annexure 6 to Annexure 15. To conduct a detailed spot inquiry and to ascertain and verify the facts at the ground level, the undersigned passed an order dated so-and-so in which Subdivisional Officer Dadangiri, Mr. Sadhu IAS, was directed to cause a detailed and comprehensive inquiry into the matter and submit the findings of the undersigned. Upon close perusal of all the records and documents and further upon scrutiny of the inquiry report of C. So-and-so and depositions, the following findings are pertinent. A brief summary of the case is followed that the complainants Faluda Biswas so-and-so were working as teachers at Rajpur Girls SSA during 2002 when the government of Meghalaya took over the school under the SSA scheme. The SMC of the school was constituted by memo number so-and-so dated 7/5/2003 by the then Deputy Inspector of Schools Dadangiri. Funds amounting to rupees 78,000 were released under the SSA towards the payment of salaries. But the complainants alleged that they did not receive the salaries. Subsequently, the then Inspector of Schools Dadangiri conducted a spot inquiry and found that the salary was not paid to the genuine teachers. He therefore directed the then Secretary SMC to pay the salaries immediately to the complainants. Till no, the complainants have not gotten their salaries for the period even after the directions of the Honorable High Court. As per the High Court order in paragraph 6, the scope of inquiry was ascertained. It had directed to conduct an inquiry to find out who had misappropriated the said amount of rupees 78,000. Following these orders, this inquiry identified some key issues: whether the complainants Faluda Biswas and others had actually worked during the said period, whether the funds were disbursed or not, who actually misappropriated the said amount. After a detailed public inquiry in which opinions and depositions were taken from the members of the SMC and the general public, it is found beyond doubt that the complainants actually worked during the said period. It is further found that the amount of rupees 78,000 had been disbursed and had not been received by the complainants. All relevant records concerning this have been enclosed along with the inquiry report. The spot inquiry conducted by Deputy Commissioner so-and-so is also gave the same findings. all the complaints along with the complaints along with the then president of SMC so-and-so alleged that the amount was misappropriated by the secretary of so-and-so, late Mokhtar Hussain. As he has already been expired, this inquiry could not get any statement on defense on behalf of him. After going through all relevant documents and conducting public inquiry in the school premises, it is found that the said amount of 78,000 was withdrawn with the joint signatures of both the president and secretary of the SMC and the secretary of the SMC. Both the president and secretary are jointly responsible for disbursing the money to the eligible persons. But the alleged established procedure was that the secretary of the SMC used to disburse the money after withdrawal from the account in his capacity of operating head of the SMC. Hence, this inquiry feels that the then secretary of MSC was responsible for misappropriation of the said amount. However, with the demise of the secretary of the school managing committee, the question arises about the recovery of the said misappropriated amount. The depositions and submissions made by the petitioners do not apportion blame directly on the president of the said management school. However, it is also unclear whether the president of Rajpur school took action upon receiving complaints or not, or whether there was any lapse on his part. The directions of the Honorable High Court were to ascertain the culprits behind the misappropriation, which has clearly been found to be the secretary of the school managing committee, who was dealing with the cash and was directly responsible for the disbursement. As such, direction is given to the officer in charge, Fulbari PS, to register a case and investigate the matter and lodge FIR the case as per directions of the Honorable High Court. So this first part is complied with. Then what happens is your Lordships may kindly come to page 61. This is Annexure 9. Well, this is a letter issued by the Deputy Commissioner to the Superintendent of Police, West Garo Hills, Tura, dated the 31st of January 2014.
Yes.
Well, this is to inform you that in pursuance of the Honorable High Court order dated so-and-so, directives were issued given by to the Deputy Commissioner to cause an inquiry and direct the officer in charge to concerned police station to act against the culprits. In this regard, please find enclosed my order dated 17/12/2013. It is not known what action has been taken by the officer in charge of Fulbari PS. This being court matter, kindly instruct the officer in charge to immediately lodge a FIR and in the case and arrest the culprits. Well, that's all that is done. Now, my lords, at Annexure 10, at page 62, my lords, this is a report which is given by, my lords, SIR Kurkalang of Fulbari PS to the OC of Fulbari PS, my lords. And it says, my lords, if I may just take your lordships to the last two paragraphs. Earlier is, my lords, what were the directions?
Yes.
The order directing the OC Fulbari for registering a case during preliminary inquiry, it was found that the prime accused who was involved in the misappropriation of the salary of the then managing secretary of the Rajput Girls, Mokhtar Hussain, has expired. However, the school managing committee is also liable of the same, including the president of the SMC. A regular case under appropriate section of law may kindly be registered against the president and members of the SMC to find out whether the other co-accused involved in the scam to deliver justice to the victims. Well, all this is done. Now, in the meantime, my lords, I was writing repeated representations to the school that, my lords, kindly give me my salaries. Now, all that was not happening, my lords. As such, I was before your lordships. Now, once I come before your lordships, my lords, the matter takes a very interesting turn. Two aspects, my lords. They say that A, the police registered an FIR, did an inquiry. Interestingly, my lords, in the affidavit filed before this honorable court, they say that 78,000 was not misappropriated. They say all other teachers, including the three other persons, my lords, who had appeared before the Deputy Commissioner and whose statements were recorded by the Deputy Commissioner, even they have been paid. It is only me who has not been paid 9,700 or 9,800 rupees, because they say I did not accept it. That is the first part of it, my lords. And a very interesting story is now carved out before your lordships, saying that there are two schools with the same name, and, my lords, it is alleged that my school is not the actual school, it is the other school which is the actual school. So therefore, the current salaries in respect of, my lords, whatever is accrued has to be paid to the other school, and I am otherwise not entitled for any benefits under the from the government. I'll take your lordships very quickly to that affidavit, my lords. Your lordships, this is the first affidavit filed by them on 22nd
Filed
of,
by the state.
I'm sorry, state, my lords. Filed on the 22nd of May 2015. Now, what is very interesting, my lords, is it is the same person who's swearing that affidavit.
Same person means?
My lords, if your lordships, before your lordships get into the affidavit, my lords, at page 59, your lordships will see who is the person who had made the inquiry, my lords, at page 59.
Yes.
It was one Mr. Praveen Bakshi.
Yes.
And who's the person who's swearing the affidavit before your lordships, my lords, in 2015? It is again the same Mr. Praveen Bakshi.
Yes. In what capacity?
As Deputy Commissioner, my lords. Deputy Commissioner come Chairman SSA.
Yes.
Well, paragraph 5 at page 2 of that affidavit, if your lordships can come. That's the relevant paragraph. The rest are not really relevant.
Yes.
Your lordships have it, my lords. That, in respect of the amendments made in paragraph 7 to 14 of the petition, the answering respondent humbly submits before this honorable court that the issues raised in the petition in paragraphs 1 to 14 and earlier been brought to the notice of this honorable court via writ petition registered as so-and-so and contempt petition number so-and-so. The answering deponent would beg to bring to the notice of this honorable court that in compliance of the judgment and order dated so-and-so had convened pronounced in WPC number so-and-so had conducted an inquiry and called all parties concerned so as to ascertain on the veracity of the facts and circumstances of the matter pertaining to the non-payment of areas of the alleged misappropriation of funds, and thereafter passed an order dated 17th of December 2013. I had taken your lordships to this order, to the effect that the officer in charge Fulbari PS is to register a case and to investigate on the crime alleged to have been committed. The said case has been registered as Fulbari PS case number so-and-so. In the course of the inquiry investigation, the investigating officer found that the salary amounting to rupees 50,000 meant for the teachers had been disbursed to the teachers appointed by the managing committee Rajpur Girls and had been duly approved by the joint district coordinator Dadingiri, West Garo Hills district. The statement of the teachers had been duly recorded by the investigating officer wherein they have stated that they have received the salary for the year 2004-2005. Your lordships will kindly recollect, we are dealing with 2003. Nothing with 2004-2005 at that stage. As sanctioned by the Sarva Shiksha Abhiyan, the statement of one of the teachers, Rukhsana Ahmed, however, could not be recorded due to the fact that she had left the school after a marriage and settled in Saudi Arabia. It is pertinent to state that even the remaining salary of 28,000 had been withdrawn by the administrator Rajpur, who was the then Deputy Inspector of Schools Dadingiri, and the said salary had been paid to all the teachers. The only person who did not receive the salary amounting to 9,400 only was the petitioner, who refused to accept the same as she demanded that she be appointed as the headmistress of Rajpur Girls Upper Primary School. This was revealed to the investigating officer during the course of investigation of Fulbari PS case number so-and-so. It is pertinent to state herein that the school of the petitioner, if in existence, had not received any approval from any authority. And this is apparent from the fact that the school Rajpur Girls Upper Primary School, recorded and reflected as per the records maintained by the District Information System for Education, reflects only the Rajpur Girls Upper Primary School headed by Shri Sobeda Khatun. The school claimed by the petitioner is seemingly a fictitious school whose existence is unknown to the authorities. Printed copy of the records maintained by so-and-so. My lords, if I may just pause here for a second. Your lordships will see that in this relevant paragraph, my lords, two statements which are directly contrary to each other, my lords, are being urged before your lordships in the same breath. A, my lords, the relevant period for which this honorable court had directed inquiry was 2003, February and March 2003. In his very report, my lords, he says that I have recorded everybody's statement. It has found that these teachers had actually worked. Money had been disbursed, but it was never paid to them. Subsequently, my lords, he comes before your lordships and says, for 2004-2005 they have been paid. And only the petitioner did not take that amount of 9,400 rupees. So what they do, my lords, that 78,000, they divide it into two halves. 50,000, they say, withdrawn, paid, and accepted by the teachers. With regard to 28,000, that is also being paid, only I did not receive, so they reduce it to 9,400 rupees. Fact of the matter remains, my lords, can the same person in the same capacity who had earlier made an inquiry come to certain findings, swear an affidavit before your lordships, taken a directly contrary stand to what is there in his own affidavit and relying on his own report? That's first part of it. Now, second part, my lords, interestingly, he says, this argument of two schools comes up, my lords, because he says, if it all it is in existence, it is not recognized by the authorities. If it is not recognized by the authorities, my lords, where was the occasion for you to offer the salary to me and for me not to receive it? My humble submission before your lordships would be the quintessential case of approbate and reprobate, because they do not know what they're talking about. And my lords, I will continue further. Your lordships will kindly see in paragraph 6 what they say. That in reply to the averments made in paragraph 15, your lordships have it, my lords.
Yes.
I'm sorry if I...
Please.
That in reply to the averments made in paragraph 15 and 16 of the petition, the answering respondent would say that as stated above, a direction was given to the respondent number 3 by the order dated 17/12/2013 to the office in charge Fulbari PS to register a case and inquire into the matter. In compliance with the said order issued by the respondent number 3 had directed an FIR dated 31st March 2014 was lodged and registered at Fulbari under section case number 7 bracketed 1 of 14 under section 409/34 IPC. As stated earlier, an inquiry investigation was conducted wherein it was revealed that there has not been any form of misappropriation nor anomaly in the disbursement of salary to the teachers, and the only problem caused was the refusal of the petitioner to accept the salary of 9,400. Lords, I am baffled as to how the same person can take these two different stands before this Honorable Court, especially when he is acting under the directions of this Honorable Court. They completely do away with the fact, my lords, that 78,000 was due. Because if at all, my lords, and your lordships would recollect, that it was a detailed inquiry. It was not a superficial inquiry. He directed everybody to be present. He recorded their statements, conducted spot inquiry, conducted public inquiry, then records those 3 findings, directs OC, register case. Now, OC, my lords, interestingly, how this entire case has come about and doing a complete U-turn, 78,000, forget it, only 9,400, and that also you did not take. And then the second plea, my lords, that this is a fictitious school. So therefore, why was the requirement of paying any money to me? So it is on that backdrop, my lords, I had taken your lordships to the prayers made in my writ petition. So the first issue is, my lords, the money with regard to the recovery of that 78,000 rupees. Till date, nobody has seen what has happened to it. And my lords, if at all a case has been registered, my lords, it was incumbent upon the state to at least place the records of this case before your lordships. What is the status of the investigation? Assuming, my lords, that they did not find anything in it, it would have to be returned in a FIR.
Yes, I think an observation was made that the then secretary had, since
has misappropriated the money.
He has
Who's no more?
No more.
No more.
Now the case would in turn be registered against the
other managing committee members.
Members of the managing committee.
My lords.
So that has not been done.
Apparently, my lords, I do not even know what has happened to the case. Supposing, my lords, I am just stretching my imagination. Supposing, my lords, nothing is found out after investigation of the case, it would still have to be returned on FR.
Exactly.
The deputy commissioner, my lords, he is swearing this affidavit in the month of May 2015, where he says all this inquiry is done, there is nothing in the matter, because he makes a categorical statement, my lords, that there is no anomaly. If there is no anomaly, my lords, it had to be returned on FR.
Yes, Mr. Saguta. See, at this point of time, I think it will be relevant.
We had submitted 2 inquiry reports upon the directions of this honorable court.
What about the direction for institution or filing of the FIR?
My lord, that stage is already gone, my lord, and that stage has already been dealt, and we have appropriately replied also, my lord. The IO also was called up to answer upon it, and the IO categorically stated that there was no, whatever that person has
Exactly. Now he has said that then secretary had expired.
Yes, my lord.
So case has to be registered against the other members of the school managing committee.
That
was that done? Because you see, the idea is to recoup or recover the allegedly the misappropriated money.
But then what happened, my lord? After that also, my lord, this honorable court was pleased to issue directions, my lord, for the director of education to conduct an inquiry and find a report, my lord. That report now, after all things said and done, my lord, we had made an effort and we had filed a detailed affidavit by the director, my lord. What happens to the report of the director now?
I am yet to deal with that report.
No, my lord, if that is non-existence, that is not there. But a report has been called by this honorable court, and a report is already placed on record, my lord. And we are saying that now the school is of fictitious nature, my lord. Now the disputed questions of fact whether this honorable court will now, because our version is different and the writ petitioner's version is different now. They are saying that they are still the teacher who is entitled to get a salary, and we are saying you don't exist. So now that is why we are saying, my lord, in a writ proceeding, and if our officers' versions are not believed, my lord, from time to time, then what else, my lord, I don't know to pray for. Our officers have been asked to give a report from time to time. We have been conducting inquiry. We are submitting report. After report is filed, nothing is given or any finding is given to the inquiry report. That inquiry report is wrong, and we do not consider this as correct.
Okay, let's take this point. As far as the 2 schools are concerned.
Yes, my lord.
You say that there are 2 schools of the same name.
And there are documents to show that
one is fictitious, and one
of the managing committee is there, which says that our appointment is already terminated. So question
we're
of
not
giving
going to that first.
No,
first
my lord, if our appointment is terminated,
first we look at the composition of the school. You see, if you say one because now there are 2 schools with the same name, same nomenclature, everything same. So one is fictitious and the other is genuine. So what have you produced records to differentiate between these 2?
Yes, my lord. Yes. My lord will kindly see to my affidavit
on 2022, my lord. Photographs of a spot inquiry of 2004 and 2008 are put
look
in.
into my affidavit.
I am not even getting into that aspect of the matter at this stage.
If you, it has come on record only on the direction of this court.
Not on the material aspect. The thing is that you see, whatever correspondence or whatever official records you have with you to prove that one school is fake and the other is not. As far as the genuine school is concerned, you will have relevant information with you.
Yes, my lord. It is there in the record.
Which will prove that the school said to be the school of the petitioner is fictitious one.
For a moment, my lord will kindly take my affidavit, my lord, dated 29/8/2022, my lord. It is given by the Director of School Education and Literacy in compliance to order dated 21/7/2022. A responsible officer has filed this affidavit. Either it has to be turned down as wrong or it has to be respected, my lord. August 2022.
Yes.
My lord, this is by the Director of School Education. My lord has got it?
Yes.
My lord will kindly come to page 4, my lord. Report. I'll just read the contents of the report, my lord. I'll not speak anything beyond which is not on record, my lord. Introduction. Rajpur Girls Upper Primary School was established in the year 1998 by the residents of Rajpur village, so Fulbari Police Station, West Garo Hills District in the year 2000. The school was brought under Sarva Shiksha Abhiyan scheme for payment of salary as well as construction of new school building. At the initial stage, the following are the teachers teaching in the school. Srimati Sobeda Khatun BA passed, headmistress. Number 2, Srimati Tanuja Begum PU passed, assistant teacher. Srimati Moriam Begum PU passed, assistant teacher. Srimati Faluda Biswas PU passed, assistant teacher, later terminated due to long absence. We are not saying that she was never the teacher. She was the teacher. Subsequently, she opened another school, my lord. And that is where, after that termination and everything happened, my lord, if her cause of action has to continue, she will first have to establish that she was a teacher and her termination was not in existence. It was originally she was part of the same school. Later on, which because of certain differences, another school has come up.
Also,
and now, on the basis of
you mean
this,
to say that the other school was set up by her?
yes, my lord.
Well, it's only one issue.
And
before even going into what my learned friend is arguing, what we were at, salary for the month of February 2003, March 2003. Your Lordships may kindly come to serial number 2, setting up of this fake school in the same name. Faluda Biswas petitioner has set up her own school in the year 2004. Assuming, my lords, the so-called responsible officer is saying the gospel truth before your lordship, what happens to the salary for the month of February and March 2003? And all those other teachers were very much, my lords, because the finding of the deputy commissioner was very specific.
Yes, because
they had worked.
You see, Mr. Sengar, as in 2002, she was still a teacher there.
My lord.
Along with those other 3 persons, my lords.
Yes, along with this, of course.
No, the names are different. The 3 people who had appeared before the deputy commissioner, my lords, who the deputy commissioner records are finding who were teachers in that school and who were not paid the salary, they are not the same people.
Oh, they are not.
What I'm submitting before your lordships is, my lords, it's a hogwash.
But are you saying that, see, this paragraph 1,
my lords,
where your name figures,
terminated, my lords, even if I'm terminated, my lords, it would...
Let's
forget the termination part of it, my lords, for the time being.
It still proves that you, once upon a time, were
part of the school. What happened is, my lords, I was part of the school, I continued to be in that school. The other person, my lords, the headmistress shown over here, Shobeda Khatun, she went and, my lords, had some other institution by the same name.
Oh, it was she, not you.
That is my case.
That is why I am saying, my lord, these are disputed questions of fact which...
No, I am not, which is why, my lords, in the first instance, my lords,
difficult to establish and
if I can just
finish.
Which is why, my lords, in the first instance, I said I am splitting my prayer into 3 parts. First part is only with regard to the salary for that relevant period and the 78,000.
Exactly.
There is no dispute. I was teaching in the school along with those other 3 people.
Till 2003.
My lords. Even assuming their portion of the story is correct. Not conceding, my lords.
Exactly.
What happened to it?
Now we come and say that you have refused. Is there any written assurance or...
my lords, if I had refused, this is the 5th round of litigation before your lordships. Your lordships have seen the observations made by this honourable court on the last round of litigation. No appeal preferred from there. In compliance, my lords, Deputy Commissioner conducts an inquiry. Your lordships have seen the inquiry report.
My lord, there is another affidavit, my lord, dated 10/6/2019, my lord. It was filed by the administrative officer of the school education department, my lord, wherein the resolution showing that the termination, my lord. Termination of this petition
is when?
2004. 15/7/2004.
So 2004.
Yes, my lord.
Let's okay. See.
It is in resolution number 2, my lord. See. And of course, no formal.
No, for a while, let's say that she has been terminated in 2004.
Yes, my lord.
But what happened to 2003 and 2002, where she was still the teacher in that school? And now the issue before this court is the demand of the petitioner for her salary pertaining to the year 2003.
2003.
So we are on that. Now you say that she has refused.
Yes.
Where's the evidence that she has refused? Is there any written
that is, I believe there must be some affidavit submitted by the IO, that than IO, my lord.
And why would the IO?
Because IO was, the deputy commissioner has directed for registering of a case, my lord. Then the IO came into picture, my lord.
IO is not a party in these proceedings. Obviously, no affidavit can come.
Yes.
Just a minute, my lord.
The IO who has submitted the report,
Going
whatever.
back in time, my lord, is making the case very difficult for me to even reply, my lord. There was an affidavit, my lord. I have seen, my lord, on behalf of some police officials, my lord. So, is there, my lord?
You're referring to which document?
Even in the affidavit filed by Mr. Parveen Bakshi as Deputy Commissioner cum Chairman, my lord, there in paragraph 6, my lord, he categorically states that there has not been any form of misappropriation nor anomaly in the disbursement.
That is true. That is, we are on that now. We are on that. That he said that offer was made to her of that 9,000.
Yes, 9,400.
But she has refused.
She refused.
So where is the evidence that she? There must be some register. There must be some letters. There must be some.
It must be with the managing committee asking her to come and collect, and so it is not part of the state record, my lord. Education department does not. We have on what basis we have?
If the petitioner now comes and says that I have not refused, then what do you say?
Then the managing committee will have to make them
Where's
offer again.
Where's the affidavit? Who's paying for the managing committee? Have you? Where is your affidavit?
Two.
What is the date of the affidavit?
It was filed on 12/5/2015.
My lord will kindly allow me to just place this on record, my lord. Affidavit dated 16/6/2019, my lord. This is a status report which says that, my lord, I'll just read the paragraph, relevant paragraph. That, sir, FIR wide number 71 of 2014, 31/1/2014 was registered by the IO of the case of Fulbari PS, and a final report wide number 43 of 2015 dated 27/7/2015 was registered in the Court of Judicial Magistrate First Class, West Garo Hills, Tura, by GR 10/14 Fulbari PS case number 071 of 2014 under section 409 and 34 IPC State versus so and so. It is humbly submitted that the case was disposed of by order dated 30/11/2015 with an observation that the prime accused of the case has expired and no material was found to fix the responsibility on the other members of the school committee while accepting the FIR filed by the IO.
No, that was acknowledged in the affidavit of the Deputy Commissioner.
Yes, my lord.
But that is in the categorical backdrop of the observations made by the IO,
what I
saying that the main person is dead, so the responsibility will go to the others.
Exactly. So now we go to the next steps.
The next step is that the IO, it seems, my lord, the IO says that there is was found to fix, nobody was to be found to fix the liability, my lord. That is, it has come on the same report itself.
That's the kind of investigation we've had, my lords.
Whatever, this is our quality or good quality or bad quality, but at that point of time it has been dealt in that manner, my lord. Now going back in time, we can, of course, my lord can direct that in that respect you file fresh and examine and file a fresh case if required. We can do that, my lord. But going back in time to correct that wrong will also be a very difficult
You see,
task, my lord.
in the light of the criminal investigation, now the assertion of the respondent that there has been no misappropriation.
Or the prime accused has already expired.
Is it so?
That is what it has
because the prime accused has expired, so there is no misappropriation.
My lord, it will be difficult, all the more difficult
The Deputy Commissioner makes this statement on oath before your lordships. Categorical. There is no misappropriation.
So, my lord.
And the school respondents, my lords, the managing committee of the school, they, my lords, say regarding 58,000, 28,000. Regarding that offer to me and non-acceptance, my lords, in paragraph 8 is not relevant, is not available.
That, sir, in addition to the above submissions, I am to humbly state that out of 78,000 found to be misappropriated, it is submitted by the IO of this case in his effort that an amount of rupees.
My friend is reading something. Let him finish, my lords.
50,000 withdrawn by the then Secretary and President was fully paid to the concerned teachers, including the petitioner, but the petitioner did not receive her due amount of rupees 9,400, and the money remained with the Secretary till he expired. Annexure C. This is part of the affidavit dated 16/9/2019, my lord. So
yes, that has been read out.
So, my lord.
That is not the correct position.
Who are you?
I am the president. I was the then president. That is not the correct position. As per my affidavit, my lord, I have sworn. In the year 2002, this school was undertaken by the SSA, and in the year 2004, the government sanctioned an amount of 78,000 to so and so school as salary for the teacher staff for the period of 2002 to 2003. The same amount was withdrawn by the joint signature of me, that is the president, and the secretary of the managing committee, late so and so, and the same amount was kept with the secretary. Secretary tried to forcefully pay 2,000 each for the teachers, but the teachers denied to take the money, and the money was with the secretary till he died. That is the position. It is not that the teachers denied because the amount was reduced. For that, the teachers denied to accept the money.
So now that's another twist.
That I'm swearing on the whole thing.
And the managing committee nowhere says, my lords, that money has been offered to me.
That is why I am saying, my lord, this is a.
Now he is saying that the offer was 2,000 each, which was refused.
My lords.
Rightly so.
Something is fishy, my lords. What I am trying to humbly submit for is something is fishy.
So let
Mr. Paul, Mr. Paul, from what could be Mr. Paul, what could be understood is finally, as luck would have it all boils down to the then secretary. He has already expired.
My lords.
And all the, let's put it this way, all the secrets have gone with him.
I would say it has not gone, my lords.
Because
government money, my lords.
Government money, but
somebody would be
now the president says that the money was in his possession.
Maybe, my lords. Maybe, but some responsibility has to be fixed. You cannot come to that conclusion,
yes,
my lords.
That apart.
Because what is, my lords, your lordships will kindly appreciate, what is the fallout of that? Fallout is, secretary is dead. 2004, there was a fight. We threw you out. You went and established another school. So yours becomes a fictitious school. This becomes the real school. The lordships will see the tree that is emanating from, my lords, that 78,000. And, my lords, on affidavit before your lordships, Deputy Commissioner is taking a complete U-turn, swearing something. IO, what kind of investigation he has done, my lords, only he knows better. Managing committee nowhere says that money was offered.
All this disputed question of facts can be decided in this writ proceeding.
That is what, my lord. Going back in time to correct certain wrongs also will be very difficult, my lord.
It cannot be a case of fait accompli, my lords. It cannot be a case of fait accompli. What's being urged before lordships, it cannot be a case of fait accompli.
And all disputed question of facts, my lord. The managing committee is saying
exactly.
But some authority, my lords, was entrusted. He initially conducts an investigation, comes to some finding. Now, if that very authority, my lords, takes a complete U-turn and comes before your lordships.
What we can do is, I don't know. Perhaps this court again has to direct for a fresh inquiry.
My lord, this will be the third inquiry, in fact.
Whatever. See, we are not yet satisfied with the result. With so much of contradiction.
But
And
with the timeline, my lord,
like I
with the
said, see,
timeline will be very difficult, my lord.
Timeline is not. See, it is incumbent upon the. Let's put this way: incumbent upon the.
My lord,
the IO
instead of an inquiry, my lord, let the petitioner explore any other possibility. Let them file a fresh writ petition with all the relevant documents, if available. Otherwise, my lord, asking my officers to again cause an inquiry or I
Failing to do their job, my lords, would necessitate me to go and initiate a fresh proceeding.
My lord,
well, I am just stopping short of pressing for perjury before your lordships.
No, it's not. It's nothing about that, my lord. My report is already on record, my lord, because a direction was already given to the director, my lord. The director, whatever possible relevant documents could be collected, evidence, we have filed it on affidavit. On affidavit, we are saying that the only conclusion is that there are two schools with the same name. So after this, my lord,
even if that is so, see, now that becomes again we go back to the same thing as what has been submitted by the councils here. That becomes a disputed question of fact as to which is the genuine school, which is not. Now this court cannot go into that.
Correct, my lord.
It is incumbent upon the authorities concerned to go into that aspect of the matter, and there is no report on that.
In that case, my lord, liberty could be given to the state authorities, my lord, to act and demolish any school which is found which is not in conformity with law. We will definitely take action, my lord.
What you have to do, see, as the state, what you have to do is you just need to check your records.
Our record says that
just check your record and ascertain as to which is the genuine school and which is not, and deal with that aspect of the matter. Then, as far as the petitioner is concerned, her prayer is a totally different prayer. Divorce of the fact that there are two schools with the same name. She has come here for her dues, which is due to her as in 2003. Now let's assume that the amount has been misappropriated. We cannot get the culprit now. He may be dead. Even though he is dead, he may be the culprit, he may not be. So we don't know. But the fact is remain that she has to be, for her entitlement, she has to be paid. Now, who is to do that? It's incumbent upon you. You have to devise ways and means to pay her dues, and how you recover it, that's up to you.
My lord, insofar as our obligation to pay, my lord, it was already done, my lord. We cannot be burdened with an additional.
Exactly. Now we are not. At this point of time, we are not saying who is right, who is wrong. You say it's done. Perhaps the managing committee will say no, or they will say yes. So now, as far as the fight is concerned, it's between you and the managing committee. But as far as the petitioner is concerned, what is due to her has to be given. And of course, subject to what the records will say. If the record says that she has not been paid for that particular period, then she has to. I think that would be the main, as far as the prayer here is concerned, that would be
the meat of the matter.
So let us not go back into the. Yeah.
Yes, my lord. Insofar as the previous inquiry report is concerned, we have done it, my lord. And if my lord again directs, my lord, we will definitely again relook into the entire matter, my lord, and we'll make all efforts to find out the truth, my lord, and in a better way, my lord. We are not saying that what we have done is right or wrong. We are not concluding at all, my lord. So we'll try to do our level best, my lord. Maybe there is some scope for if my lord indicates in.
You see, Mr. Sengupta,
because
it occurs to me.
Yes, my lord.
we may have to apply what we usually do in motor accident claim cases. Pay and recover later. So you pay and you recover from the owner. Put it that way.
But these are government money. And
Exactly.
Government
exactly.
money.
Now, if that
unless if directed by this honorable court, it will be all easy for us, my lord. Without a direction of the court, my lord, my officers will find it all the more difficult to take.
But as Mr. Paul, as far as that 2003 is concerned, have you proved your bona fide?
Yes, my lords. I have. Because your lordships will recollect in the order of the deputy commissioner, he says, I have worked for that period.
Okay.
And even in that affidavit which was pointed out before your lordships, assuming, my lords, it is the gospel truth. They say I was terminated in 2004. So 2003 I am working.
The resolution, my lord. I'll just
That will open another floodgate, my lords. There's a managing committee resolution to throw me out.
That's even then.
That also has to be accepted by the government.
No, even then, you see, even then, if that is the case, we are looking at the pre-2004, period.
Lordships.
What happened after 2004?
We're not even getting there, my lords, which is why I started off from there. We're not even touching 2004.
As per resolution number 2, dated 15/7/2004, my lord.
Exactly.
So this is on the basis of the documents I am making this statement, my
you
lord.
see, we are, Mr. Sengupta, you understand the point. We are not going on into, as far as 2004 is concerned, the controversy which arose.
Prior to that, she was definitely working, my lord. It clearly indicates from these very documents. So.
And also, Mr. Day, it is incumbent upon you when now you have admittedly you have admitted that the money was given to you.
No, money was not given to me. Money was withdrawn by the president and the secretary.
Exactly. And the president and secretary means what? They represent the managing committee.
Yes, my lord. It is the duty of the secretary to disburse the money to the staff.
Exactly.
My lord. It is the secretary. Now, the money was with secretary, he died. Money was offered. Teachers has not taken because they have asked them to accept only 2,000 rupees. Now, as a president, I am only to chair the meeting.
But you see that you cannot escape your responsibility. You cannot say that I have nothing to do with money matters.
No, what if I can submit? When the teachers has not received the salary, my lord, it was me who has come before this honorable court, and this honorable court has directed the secretary to pay the money. It was me who has come before this honorable court first, before Falada Vishwas was before this honorable court. It was me who has gone to the court because the secretary was not accepting my request that you pay the money to the teachers. Then I am the one who has initiated my lord. It's not that my conduct is not good. It was me who has come before this honorable court.
Let us do one thing. I'm also still confused as to how we go about this matter.
Yes, my lord. We'll need some time to.
Mr. Paul, I think we need to
some instructions.
Put our heads together and think of a way out.
In the meantime, I would also
help the government, to work out. See, now it appears that you are entitled to the money. There's no doubt about it. You have to pay. But how you do it in the light of what has happened, particularly since again we come back to the same thing, since the then secretary has expired, so you work it out. There must be some way of how you do about it. You go about it.
My lord, if it is indicated in any of the orders, so
that
I can.
That will not be said.
Because,
only
verbal instruction to the officers, on the basis of my verbal instruction to the officers to do or not to do something, I might not be in the.
My lords, what I was saying is my friend can obtain instructions and place before your lordships as to what can possibly be done, and then your lordships can pass appropriate orders. Because your lordships will not be able to fathom how it can be, how the administrative machinery works. They will know.
Exactly.
So they can place instructions before your lordships, my lords, as to this is the method probably can be explored. So then your lordships can pass.
Though you know very well, you see, even in judicial review, the court can go into the issue of facts. But to what extent?
To what extent, my lord?
To what extent?
Some at certain point of time, evidence may have to be led.
Exactly.
Which evidence to be admitted, which to be rejected,
But
dismissed.
as Mr. Paul says, I think you seek instruction and see this. You have understood the situation. I think we have to be fair to all of us. We are here for justice, not to defend our cause.
I'll obtain instruction, my lord.
You seek instruction and we'll see.
Because insofar as the position of the case is concerned, it is very clear, my lord, and only...
Let's put a quietus to this whole thing.
Yes, my lord.
As far as he's concerned, once he gets his money, that's all. So it's incumbent upon you to do that. But how you get it, please seek instruction and find out who is and means.
Let it come after 3 weeks, my lord.
Matter has been heard substantially. However, in course of the hearing, the learned additional senior GA, Mr. S. Gupta, has sought for time to seek instruction and to place and to apprise this court on the next date fixed as to how this matter will proceed as far as the issue of payment of the salary due to the petitioner is concerned for the relevant period of 2003, only for 2003. As paid for, this is matter after
February, March.
3 weeks. So 3 weeks.
Item number 7.
Tomorrow, what about?
Please, Your Lordship. I'm just praying for a day's passover, my lords. This matter can kindly be listed tomorrow.
Not tomorrow. No, no. Some other matter is supposed to be listed somewhere else, so it's not listed.
1 week.
Well, it's actually I was supposed to inform Lordships of the factum of the client's death, if Your Lordships recall. I have instructions. I just need some additional instructions.
You are paying for a private.
I'll explain that.
I thought you were.
No, I'll explain that. It'll just take about 5 minutes tomorrow.
I don't know whether the government can die or not.
No, not for the government.
No, not for the government.
My friend is here for the private party.
For the private party.
Prior to his appointment, he was already having this brief.
I'll be brief, my lords.
So tell me, what is the relevance of the your client here?
She was the original complainant.
Oh, original complainant.
My lords.
So see, if she is dead, then in the matter.
So well, that's a different aspect of it.
Because then you see again.
As to who needs to cause the substitution, that will be a different issue. In my understanding, it will be the petitioners who will have to cause it because the right to suit does not survive anymore. Because the revision is not a continuation of the original proceedings, and this is not a suit. This is not a suit. A revision is not a carryover. If it was an appeal, a statutory appeal, it would be slightly different. But I'm on a different issue, my lords. I'll just have to offer some explanation as to how I came into this case and what has happened. It was a case of some miscommunication, misinstruction. Just allow me time tomorrow. I'll just explain that, my lords.
On premier parties, this is matter tomorrow.
Highly obliged.
Item number 10.
May please Lordship, here that earlier the Miss Angela was representing the petitioner Lordship. Now she has been impaneled for senior GA Lordship. So I have the instruction to APL Lordship. So I am yet to get the Wakalatnama from my client Lordship. So I'll file my Wakalatnama and I'll represent the petition in this case Lordship.
And you?
I'm respondent number 11.
11. What about the other? What is? Mr. S.A. Sheikh, National Council, has submitted that he has been engaged to appear before this court on behalf of the petitioner. However, the relevant power could not be executed, for which some time is sought for. As prayed for,
3 weeks, Lordship.
This is matter of 3 weeks.
Go through the
Item number 11.
Yes,
Lordship, this is that regarding that Hindi research, Lordship.
Okay. So there are 3 connected cases here. So
Then you tell the court if you.
3.
I think Lordship is not. Will ask for time.
who is he? You are hearing
The
for?
private respondent 5 and 6, Lordship, in my case.
Who's 5 and 6?
5 is that managing committee and the person who has replaced me.
Okay.
Yeah, Lordship, the conductor counsel for respondent number 5 is on sanction leave.
Then can we list on next week, Lordship, because he is on leave till 19. Till 19.
11, 14 and 15. No?
On premier, we'll list it after 2 weeks.
Lordship, yes.
On premier by the by the respondent. 4 and 5 by the respondent. This is matter of the respondent 4 and 5. This is matter of 2 weeks.
11, 14 and 15. Lordship.
Same
11,
order.
14 and 15.
Same order. So I have to list on list after
On the
2 weeks.
same, it will come in the same day. Apply your Lordship.
Item number 16.
We would like to pray for some time. Attend the matter.
You are for?
We are for petitioner.
On premier by the petitioner, this is matter of the 3 weeks.
Right.
Item number 18.
This is the review matter, my lord. Mr. The second half?
We'll take it in the second half.
Yes, Lord.
So second half then. At 2:15.
Second call, item number 18.
Yes.
Please, Your Lordship, before starting, they have challenging that I have not challenged the order of the private respondent for appointment as a headmaster of the school, my lord. That is their, for that reason they have filed the writ petition. So I will go to my prayer. In the writ petition it is, they have enclosed in page number 37.
Who's to start?
No, before my starting, I am pointing out that things only.
The issue is not with regard to challenge to the appointment of my learned friend, Malas, because he had approached this honorable court. And what we have sought review is on the only limited ground, Malas, is that there was some kind of a fraud played upon this honorable court for the purposes of obtaining that order. Only on that limited ground, my review has been preferred before your lordships. I'll take your lordships, Malas. Well, as the writ petition filed by the petitioner, my lords, your lordships would find at Annexure 1, page 19. And at page 37, my lords, is the prayer. Your lordships.
Yes, sir.
Give me the page number from here. That's it. You should always mention the page number in your note.
Page 37.
Balance.
Yes.
If your lordships have it, may I read minutes. In the premises aforesaid, it is most respectfully prayed that your lordships would be graciously be pleased to admit this writ petition. Issue rule calling upon the respondent authorities to show cause as to why a writ in the nature of mandamus and or certiorari or appropriate writ order or direction should not be issued to set aside and quash the impugned letter of termination dated 24/8/2017 and direct the respondent authority to reinstate back the petitioner in service with full service benefit and or as to why the entire case record should not be called for a proper adjudication of the matter and as to why a direction should not be issued directing the respondent authority to release the entire salary of the petitioner and as to why the appointment of the private respondent Mrs. Sengachi M. Sangma as headmistress in place of the petitioner should not be set aside and quashed and replaced by the petitioner and show cause if any whatever, my lords, and in the meantime stay of that impugned proceedings. Now, for the purposes of, my lords, the writ petition, the petitioner, my lords, had annexed his initial appointment order at page 50, my lords. Write down in your note.
Yes.
Well, let's kindly see, this is an order dated 15/2/2000 and it is by Shri, it says, my lords, Shri Sengachi M. Sangma, PU, is hereby appointed as assistant teacher on a consolidated pay of rupees 3,000 only per month with effect from the date of joining. Copy for information and necessary action. Now, what we had pointed out before your lordships is,
Yes.
But even though, my lords, the order is typed, the name of the petitioner, my lords, appears to have been written by hand.
Okay.
To produce the original.
Yes.
That is, lordships. To that extent, my lords, some orders were passed by your lordships, my lords. Well, if I may draw your lordship's attention to the order dated 28/11/2022.
Yes.
Lords had directed both the parties to file their respective originals by way of an affidavit before your lordships, my lords, and that was accordingly done. Not this, the original school records. No, they give it to us. All the registers. They have. Get the records. My lords, thereafter your lordships have passed an order on 7/12/2022, my lords. And if your lordships have that, my lords, though this court is not in a position.
Yes.
My lords, though this court is not in a position to authenticate the same as to whether they are original or not, the parties have submitted that to confirm the authenticity of the appointment orders, the relevant school records may be allowed to be produced before this honorable court. Limited exercise indicated the review petitioner is allowed to produce the said records on the next date. The documents produced before this court today are returned to the parties concerned with the direction that the same be produced on the next date. My lords, on that basis, my lords, we had originally produced the registers. Unfortunately, my lords, my friend who was assisting me somehow lost track of those registers before your lordships. We'll just produce it before your lordships right now, my lords. They've just gone to bring those registers. Because the only case is, my lords, that if what we are projecting before your lordships is that if the writ petitioner is invoking the writ jurisdiction of this honorable court, my lords, they would have to satisfy your lordships that whichever were the records that they had produced for the purposes of seeking relief from your lordships, my lords, are actually not tampered documents. That is the limited case of the review before your lordships. So to that extent, my lords, your lordships just grant me a little while. We are just producing the original registers with regard to the appointment certificates of whoever was, whatever has been the state of affairs in the school, my lords. The records are available with us. We'll just produce it before your lordships.
So at present you are the headmistress.
I am the headmistress, my lords.
Okay.
I am the headmistress. Because otherwise, my lords, there's a huge dispute that the petitioner was not coming to school and, my lords, that he was willfully abstaining and things like that. But that, my lords, in the review proceedings, I cannot agitate before your lordships.
Of course.
My lords.
This court need not tell the parties that this is a review, not a rehearing.
My lords, I cannot, my lords, I cannot go and employ your lordships to look into something which in review jurisdiction is not maintainable.
Exactly.
Unless I can satisfy your lordships on this initial issue, my lords, I don't think there is anything that survives so far as this issue is concerned. My lords, my apologies for your lordships, my lords. Those records, unfortunately, are not here in court. They've left it back. Somehow, that aspect of the matter was missed out. Your lordships may have it tomorrow, my lords. I'll produce the original records. This is only on that limited issue. Your lordships have already passed an order. Your lordships will examine whether any such order was passed or not.
Not tomorrow. After a week. On pre-made by the parties, this is matter to a week.
My lords, my sincere apologies. I was not aware that the records were not.
Fine. So we'll take it up next week. Yeah, next week. By this time maybe. Wednesday or Thursday.
My lords.